Hi, Nick. Can you hear me?
Yes, I can hear you. Hello.
Great, Nick. We're just settling the room here, getting everyone checked in. The administrative law judge is here. I believe she'll have some questions about your court reporter number and things like that when we get started.
Okay.
The previous court reporter said she had an emergency come up and said she forwarded it to you, so I appreciate you joining early. We'll get started here right around 1 o'clock.
Sounds great. My pleasure. Thank you.
And good morning or good afternoon, Cassandra. You want to do a sound check real quick as well?
Yeah, good afternoon, Chein.
And the agenda says we'll be doing some elections here before we get started.
Yes.
All right, great. Well, I'll let you call the meeting to order about 1 o'clock here and do all that. And the administrative law judge will be standing by here waiting for that.
Okay.
Thank
you, Chein. Good afternoon. 1 p.m. on December 3rd, 2025 for the Medical Board of California Panel A meeting. This meeting is now called to order. I will be doing roll call. Mr. Arkatov?
Here.
Dr. Ayala Rodriguez?
Here.
Ms. Chung?
I'm here.
Dr.
Here.
Mahmood?
Yes.
Dr. Solis?
Here.
Dr. Sai?
Here.
Mr. Watkins?
Yeah.
We have a quorum.
All right. Thank you, everybody. Welcome to Panel A meeting. This is December 3rd at 1 o'clock. We called the meeting to order and establish a roll. So we'll head to the first agenda item, which is election of new officers. As you know, our chair was Dr. Bolot, and I have been serving as vice chair. So at this time, I'd like to call for nominations for the new chair and vice chair of Panel A.
I'd like to nominate Dr. Chai to be chair of the Panel A.
Okay, thank you. Okay, there's a motion and a second. Any discussions, any alternate nominations? Seeing none, I guess we'll call for a vote. Do we need to have a roll call on this, or can we just raise our hand? Roll call. Okay. Can we please take a roll call, please?
Mr. Arkatov?
Yes.
Dr. Ayala Rodriguez?
Yes.
Ms. Chung?
Yes.
Dr. Mahmood?
Yes.
Dr. Solis?
Yes.
Dr. Sai?
Yes, and thank you.
Mr.
Okay.
Watkins?
Yes. Absolutely.
Motion carries unanimously.
Thank you. Thank you for your support. I'd like to open the nominations up for vice chair. And I think that Ms. Annie Chung is my nominee for vice chair. Any seconds for that motion or any other nominations?
I second that.
There's a motion and a second. Any discussions or any alternate nominations? Seeing none, I call for a vote.
Mr. Arkatov?
Yes.
Dr. Ayala Rodriguez?
Yes.
Ms. Chung?
Yes, and also thank you.
Dr. Mahmood?
Yes.
Dr. Solis?
Yes.
Dr. Sai?
Yes.
Mr. Watkins?
Yes.
Motion carries unanimously.
All right. Thank you, everyone, for your vote of confidence, and congratulations to Ms. Chung. We will move on to our second agenda item, where at this point I will turn it over to our honorable judge presiding.
Thank you. I'm Administrative Law Judge Juliet Cox. Oops, thank you so much.
You're welcome.
I'm Administrative Law Judge Juliet Cox from the Office of Administrative Hearings, and the Medical Board has asked me to assist in 2 oral arguments today. The first one on the agenda is oral argument following a remand to from the Superior Court in the matter of Connie Chein. Is Dr. Chein or Dr. Chein's counsel present? Wonderful. Yes, now on the video screen, I see a label for Philip Bosch and Dr. Chein, but I don't see y'all. If you can make yourselves visible, I'm sure it'll be easier for the panel to hear what you have to say. There we go. Good afternoon, sir. We can't hear you though either.
Audio is still not coming through. We can see if it came off mute, but it doesn't seem to be
Right,
coming through.
I agree.
Are we off mute now?
There we go.
There we go.
Now we can hear you. Say something else, please, sir.
Thank you very much. How about,
Yes.
we appreciate
also
the opportunity for the hearing.
Hang on. We also should have a court reporter. Is that the other person I can see on the screen in a gray jacket?
Yes, hello, Your Honor.
Okay.
Your certified court reporter today is Nick Milana, and my
All right.
CSR number is 13912.
Okay, I'll have you announce that again after we go on the record. I always want to start in a video conference proceeding by making sure that we have all the right participants and we've got our technical issues sorted. So it seems as if we have. So, Mr. Milano, let's go on the record. All right, good afternoon. We are now on the record in the matter of the oral argument on the accusation against Dr. Connie Chein. This matter is Medical Board case number 800-2021-074735. And it is here today in front of Panel A for oral argument after a remand to the panel from the Los Angeles County Superior Court. I am Administrative Law Judge Juliet Cox from the California Office of Administrative Hearings, and I will be assisting the board in this argument. I would like to begin by having counsel for the complainant introduce themselves, please.
Good afternoon, Your Honor. This is Philip Bosch of the Bosch Law Group. And
Mr. Bosch, I was
representing-
actually asking counsel for the complainant to
Oh,
introduce
I'm
herself,
sorry.
and then I'm
You
going to
would
ask
be-
you.
Appellant, I suspect. Thank you.
Good afternoon, Rebecca Smith on behalf of Respondent Medical Board of California.
All right. You've said respondent. I guess that's in this posture, I suppose that is your position here. Mr. Bosch, would you introduce yourself for Dr. Chein, please?
Yes, thank you. I'm appearing, Philip Bosch, Bosch Law Group, appearing for Dr. Connie Chein, who is with me in the conference room here today.
Thank you. And can I have our reporter also please introduce yourself for our record?
Yes, good afternoon. Your certified court reporter today is Nick Milana, and my CSR number is 13912.
Thank you. All right. We have 13912. You have received some notices inviting you to present argument based solely on the record that was developed at the administrative hearing in this matter. It's my understanding that the respondent, I guess, who was the complainant earlier, will have 15 minutes, and Dr. Chein also will have 15 minutes, and then we'll throw it back 5 minutes and 5 minutes for any further statements. I would suggest as well that if any of the panel members have questions, that they perhaps ask those questions after the first 15 minutes of argument so that you may address both the questions and then also any answers you heard to questions that were posed to the other side during your final 5 minutes. Does that make sense to everyone?
Yes, Your Honor. May I ask, because petitioner requested this remand to the board, she opens, correct?
I wasn't sure how you all wanted to do that because we are in a little bit of an unusual position here. And that would be a fine way to go, I think, because the board has already rendered a decision that then the Superior Court has asked essentially for you to revisit, and Mr. Bosch and Dr. Chein have some argument to make about what how the outcome should differ from the outcome that this board previously adopted for this matter. So does that sound reasonable to you as well, sir?
Yes, it does. And I think that whether you want us to start first or go second is entirely up to you.
All right, why don't you begin? You'll have 15 minutes. It's my understanding that the board members have received the complete record from the prior proceedings, so they're familiar with the posture of the case, but if you'd like to refer them to particular things in the record, be sure to give them clear citations so they'll know where to look for the information that you have offered. And please, sir, the floor is yours.
Thank you very much, and thank you for all of you really for the time and attention to a matter that is not only extremely important to Dr. Chein, but also extremely important to 2,000 gynecology patients, all of whom are women, many of whom have been with Dr. Chein for many decades. And on behalf of all of these people, we're not lining them up outside this hearing room, but the sincerity of Dr. Chein in dealing with her patients and her loyalty to them is part of the reason why she perseveres so strongly here. A remand order, I would respectfully submit, is a little bit different than just an appeal. And I notice at the end of the Attorney General's argument, there's this idea that what we're going to try to do is continue an administrative appeal no matter what happens with the remand order. And that is not the case as far as Dr. Chein is concerned. She has and is not going to participate in the obstetrics practice on her own as a desire. And so there's no intent, assuming that the board adopts the position we're asking for on remand, there's no intent to continue the administrative hearing. I wanted to clarify that procedural point. The other thing that I think is important to start out with is that the Superior Court judge did recognize two things that are important to the hearing. One is that the board didn't have a chance to consider it. So on the first hearing, it's now, really. The idea of consideration being given to this point, the remand is sent so that that consideration can be given. And Dr. Chein is thankful for each of you in sincerely considering the remand order. Because the other thing that was important to us at the remand order was that Judge Chein found that Dr. Chein, quote, made a good argument in that her gynecology practice can be separated from her obstetrics practice, and that the two practices are commonly separated by doctors in retirement, and the board also has separated them in the Park case, which I'll discuss in a minute. I think it's true that Dr. Chein is asking for essentially the same relief that the board afforded Dr. Arthur Park. I would say there are two distinguishing features that make Dr. Chein's request more compelling, much more compelling than what Arthur Park presented to obtain the order that the medical board eventually issued in that case. And the first compelling difference is that Dr. Park was dealing with negligence lawsuits over the deaths of two patients. We had two deceased patients with deceased family members with, obviously sincerely prosecuting what they believed to be the negligence of a physician in causing the death of two patients. Dr. Chein, on the other hand, not only the two patients that the board was able to find, frankly, those two patients delivered happy babies and are perfectly fine now, but not once in the thousands, 9,000 deliveries, not one time has Dr. Chein ever received one Superior Court complaint for malpractice or one investigation by anybody for malpractice. It basically represents a literally perfect record being presented for discipline here. Very rare and very distinguishable from Dr. Park. The general idea that the board granted to Dr. Park was based on the separation of the gynecology from the obstetrics practice, and Dr. Chen's gynecology clients, patients, 2,000 plus strong, I mean, are very different people now than those who are actively delivering babies. And it's true that many of them, and I'd say, dare to say 100% are women. Many of these women, as I indicated, have been with Dr. Chein for years and years, and the continuity of that treatment and the continuity of the advice and the comfort level that people have after having a doctor for as long as these people have is not something to be thrown away. And at this point, the only other distinction between Dr. Park and Dr. Chein is that Dr. Park is a man. I mean, and frankly, Dr. Chein, as probably every woman professional in this room knows, Dr. Chein, as she's committed to a career that's lasted decades and decades and decades, has gone through a lot more, frankly, to prove herself than most every man. And certainly with respect to Dr. Park, I think Dr. Chein, her record with her patients and 0 lawsuits, deserves the attention that at least the board gave to Dr. Park. Now, the other thing was that the fitness to practice a particular vocation, gynecology, you know, the only thing that has come up here that Dr. Chein has dealt with, frankly, at the board's request or at the investigator's request, was a sleep apnea condition. And sleep apnea, even as part of the hearings, as you know, I mean, that was being monitored carefully. The doctor doing it was absolutely adamant that it had no impact on her ability to deliver the highest quality medical care that she'd been doing for all these years. And when they asked for proof of the compliance that Dr. Chein had with all of the regimens of the sleep apnea physician, she provided it, gave access to the computer and her personal medical materials in order to have the finders of fact determine exactly the way her own doctor did that the sleep apnea had 0 effect upon any of the care and treatment being delivered to any and all of her patients. So when you're looking at the fitness to practice of a particular vocation, which is the requirement the Superior Court is sending back here, the commitment to practice, fitness to practice the vocation of gynecology, you're talking about probably, if paying concern to the patients that are involved here, all of them would be very much seriously hurt if Dr. Chen's just removed from their care for no good reason, because she is fit to practice the vocation of gynecology, same way Dr. Park was and is, presumably. I think one of the things that the Superior Court did find was that there's irreparable injury here, and irreparable injury to Dr. Chein and her practice, which is effectively being ended if this follows through, but also irreparable harm to the patients. I mean, who count on being able to talk to their doctor in a very personal way that has been. I'm not saying that every one of the 2,000 people needs to have Dr. Chen's ear every 5 minutes. The world doesn't operate like that. But as you know, if you develop and when you develop, hopefully, the kind of relationship that Dr. Chein has with her gynecology patients, You want that person on the phone available to you whenever there's a medical issue that concerns you or your family. And Dr. Chein is always there for these people, always, whether it's referrals or answering questions, whatever it is, she's there and has been. And to take that away based on not even one gynecology litigation or dispute or complaint or no deaths, no injuries, nothing like what Dr. Park had to deal with. It is something that is not just unfair to her and irreparable harm to her, but irreparable harm to the patients for no good reason here. And Dr. Chein, to the extent that the board and the Attorney General previously argue that, oh, Dr. Chen's record keeping is bad. Well, she's enrolled in the requested record keeping course. I mean, I don't think her record keeping deserves it's bad or any type of pejorative issue, especially when that's not what was referred to the board by remand. That's not the order you're requested to look at. But it's also a situation where, as far as Dr. Chein is concerned, I think she's gone the extra mile and done what's necessary to resolve whatever lingering concerns there might be. It bears pointing out that there was no requirement that the sleep apnea be part of any type of ongoing review once they were given the proof that she's complied in every way and is not affected. There's no disability. And I don't know how many of you all have sleep apnea. I have sleep apnea and I'm not disabled, I hope. And I frankly think that it's unfair to create a new disability when one doesn't exist here. The concept here of trying to arrive at a fair resolution that doesn't endanger the public. I know that the Attorney General has very qualified, frankly, aggressive prosecutors who are concerned about the public interest, but I don't think there's any evidence, much less clear and convincing evidence, that any of the gynecology patients who rely on Dr. Chein are at risk for anything. And so, it's with respect for this board and respect for the decision-making authority that you have, and respect for the Superior Court and the hope that its mandate will be followed when the court says she's presented a good case, and take it back to the board for a decision on it. That's exactly what we've done, and we hope that you, just like the judge, will recognize that she does have a good case and she ought to at least receive the same sort of consideration and treatment given to Dr. Arthur Park. Thank you.
You have approximately 2 more minutes. Is that all you'd like to say right now?
Can I reserve my 2 minutes?
Certainly. Let's find out if there are any questions here right now before we hear from Ms. Smith, or would you prefer to reserve any questions until you've heard both sides' presentations? Dr. Tsai, any questions?
No, thank you.
Anyone else on the board have any questions right now? All right, then in that case, thank you for that argument in your presentation. Ms. Smith, what would you like to say in support of your client's position?
Thank you, Your Honor. We are here today because Dr. Chein does not want to be on probation. She's trying to avoid discipline and circumvent your well-reasoned and carefully tailored decision, placing her on 5 years probation with very specific terms and conditions to protect the public. Dr. Chein is fighting your decision, and while she fights it, she has twice asked the Superior Court to stay the decision while she challenges it. On both occasions, the Superior Court said no, because she has not shown that the board isn't likely to succeed on the merits, and she has not shown that the public interest will not be harmed. And for clarification, there has been no finding by the Superior Court that Dr. Chein is safe to practice or that she should be permitted to practice gynecology unrestricted. And to state so in Dr. Chein's moving papers, and her argument is misleading to you into undoing your decision. The first time Dr. Chein claimed that she only wants to practice gynecology was to the Superior Court, and the court properly stated that this issue is for you, the board, to decide. There is no evidence that the two can be separated without risk of harm to the public. This is just another attempt to circumvent your decision. Dr. Chein was charged with an impaired ability to practice medicine based on her clinically significant severe sleep apnea, as well as gross negligence, repeated negligent acts, incompetence, and failure to maintain adequate and accurate medical records as to 2 patients. With respect to the sleep apnea, at the hearing, Dr. Chein failed to recognize and acknowledge the very serious patient safety risk she posed if she failed to continue treatment and periodic follow-up of her clinically significant severe sleep apnea. Dr. Chein's treating sleep doctor and the board's 2 expert evaluators all agree that in order for Dr. Chein to safely practice medicine, she must follow up with a sleep doctor periodically to confirm that she's continuing to have a favorable response to treatment and that she is getting appropriate sleep. Dr. Chein's expert, Dr. Rabin, who's been her colleague since they trained in obstetrics over 50 years ago, downplayed the clinical significance of her severe sleep apnea. He didn't examine or evaluate her. He testified that he knows her and doesn't need to examine or evaluate her in order to opine on her impairment. Further, Dr. Chein herself can't be relied upon to self-regulate her sleep apnea treatment. She allowed it to spiral to the point of becoming severe and clinically significant, requiring treatment. Dr. Chein only sought treatment when it was required by the hospital following a comprehensive fitness for duty assessment after the hospital received complaints that she was falling asleep during deliveries. At this hearing, Dr. Chein demonstrated her continued refusal to independently comply with treatment. She ignored her treating sleep doctor's request for treatment data until he testified at the hearing. Only then, 10 months after the request and during the middle of the hearing, did she comply with his request. Again, she was unwilling and unable to recognize her problems on her own. This lack of insight and poor judgment is a significant concern for public safety. Dr. Chein has demonstrated that she requires oversight in order to be a safe practitioner. Dr. Chein likewise refused to acknowledge any shortcomings in her care and treatment of patients 1 and 2. With respect to these patients, the clear and convincing evidence established that she committed multiple extreme departures from the standard of care. As credibly testified to by complainant's expert, Dr. Victor Chein, Dr. Chein's documentation in both cases was so inadequate that it constituted multiple acts of extreme departures. Dr. Chein also demonstrated a lack of knowledge constituting incompetence when she didn't recognize lethal subgaleal hemorrhage as a potential complication in patient 1's vacuum extraction attempt. And she also demonstrated a lack of knowledge constituting incompetence when she was unable to use standardized terminology to describe fetal heart rate tracings and fetal station. Dr. Rabin, Dr. Chein's paid expert witness, retired peer, and retired colleague, refused to acknowledge her multiple departures from the standard of care. For example, Dr. Rabin admitted that Dr. Chein did not document an informed consent discussion with patient 1, but that she complied with the standard of care because he assumed that the consent discussion took place. Another example, Dr. Rabin used the proper standardized terminology when he summarized his review of patient 1's fetal monitor strips, and he agreed that Dr. Chein did not use the proper standardized terminology. Yet he testified it was acceptable for her not to use the proper standardized terminology when documenting her review of the strips in patient 1's medical records. Dr. Rabin did not review the matter objectively. The opinions of the board's expert witness, Dr. Victor Chein, were reasonable and supported by the evidence. Dr. Chein repeatedly argued at hearing that all her patients were happy with her care and treatment, that patient 1 was happy. Dr. Chein testified falsely regarding patient 1's satisfaction with her care and treatment. In rebuttal, patient 1 credibly testified that she was not happy with Dr. Chein's care. Dr. Chein did not explain to her the risks of the vacuum. Dr. Chein left patient 1 feeling confused and disappointed in the birthing experience. Patient 1 expressed this dissatisfaction to Dr. Chein. Patient 1's testimony illustrates that she was in fact harmed by Dr. Chein. Throughout the hearing, Dr. Chein was dishonest, tried to shift the blame to others, and was adamant that she did nothing wrong. She testified that she would, quote, like to dismiss this whole stupid hearing and go back to her job, end of quote. She lacks insight into her misconduct. At no time during this hearing did Dr. Chein state that she no longer intends to practice obstetrics. Her testimony was the exact opposite. She testified that she has pregnant patients in her practice and she plans to go back to delivering babies. The clear and convincing evidence established that her misconduct was an extreme, her misconduct was extremely serious. She committed multiple violations of the Medical Practice Act, including gross negligence in her care and treatment of patients 1 and 2, repeated negligent acts as to patients 1 and 2, incompetence as to patient 1, and failure to maintain adequate and accurate medical records as to patients 1 and 2. Dr. Chein's misconduct cannot be separated into one aspect of her practice of medicine. She didn't offer any evidence to demonstrate that her serious misconduct and shortcomings as an obstetrician do not affect her gynecological practice. In fact, Dr. Chein's very serious deficiencies in failing to provide informed consent and gross negligence in record keeping are not exclusive to obstetrics. This legal maneuver by Dr. Chein to undo your decision jeopardizes public safety. The imposed discipline is entirely appropriate and no mitigating factors warrant any less discipline. Dr. Chein's reliance on the decision entitled In Re Arthur Park for the proposition that her obstetrical practice could be separated from her gynecological practice is misplaced. The practice restriction in the Park case was specifically negotiated as part of a settlement between Dr. Park and the board, where Dr. Park admitted in a single patient case, this wasn't a 2-patient death case, it was a single patient case where a baby was delivered and the mother subsequently had an amniotic fluid embolism. In that case, Dr. Park admitted that complainant could establish a factual basis for the charges in the accusation against him, and he gave up his right to contest those charges. Here, there is no settlement in this impairment to patient quality of care case. The decision in this case followed a full evidentiary hearing where Dr. Chein was dishonest and lacked candor in her testimony. She admitted no wrongdoing and her expert was not objective. Here, the clear and convincing evidence established that Dr. Chein committed multiple violations of the Medical Practice Act and there is cause for discipline. It would be dangerous and contrary to public protection to allow her to practice unrestricted while she challenges the board's decision in Superior Court. And with respect to Dr. Rabin's declaration submitted by Dr. Chein, it is outside the record. It violates the board's order that arguments be based on the existing record and that no new evidence will be heard. Dr. Rabin's declaration is not based on testimony and evidence presented at the hearing. The opinions contradict Dr. Chein's hearing testimony and her intentions regarding her practice of medicine. Dr. Rabin was not credible at hearing, and he refused to acknowledge Dr. Chein's multiple departures from the standard of care. There is no ability here to cross-examine him on this written document. Dr. Rabin wasn't credible in person, and surely he shouldn't be believed on paper. In Dr. Chen's moving papers, she raises the issue of not completing PACE and prescribing despite the prohibition to practicing medicine until she successfully completes PACE. She argues that she has had a good faith compliance and made substantial efforts to comply with the board's decision. Good faith compliance and substantial efforts to comply does not protect the public. Dr. Chein admitted to prescribing despite the prohibition on practicing until she successfully completed PACE. Your decisions are issued 30 days prior to the effective date so that practitioners can get their practices in order. Dr. Chein is thumbing her nose at your decision. She knew in May that she needed to sign up for PACE. She refused to do so because she thinks your decision is wrong. She shouldn't be on probation. She continued to prescribe because she thinks she knows better. This lack of insight is dangerous. Oversight is necessary to protect the public. To allow Dr. Chein to practice gynecology unrestricted while she waits for the Superior Court to rule on her challenges to your decision would be a failure in public protection. If you ignore the clear and convincing evidence that requires Dr. Chen's physician and surgeon certificate to be disciplined and allow her to practice gynecology without oversight, she will then argue before the Superior Court in her writ petition that any discipline is punitive because she is no longer practicing obstetrics. The board determined that Dr. Chein requires oversight by way of probation with specific terms and conditions set forth in your carefully prepared decision in order to protect the public. Protection of the public is the board's highest priority. Public health, safety, and welfare will be harmed if the relief requested is granted. This request to modify your decision must be denied. Thank you.
Thank you, counsel. Now we've heard initial presentations from both Dr. Chein and the complainant. Are there any questions from any of the board members? We'll start with Dr. Tsai. And if you have questions for either party, you may ask them now.
Questions.
All right, Vice Chair Chung, is there any questions over there? All right, I do see a question further along.
Yes.
Mr. Watkins, what is your question and to whom is it?
This is for the attorney of Dr. Chein. A clarifying question. So up to now, your client has not completed PACE. Is that correct?
No. We've completed what we can complete. We haven't, she hasn't finished PACE because PACE is awaiting the outcome of apparently this hearing and wanting to know what kind of construct to create for going forward. But she's done everything she can do to comply with the PACE requirements. And she's officially enrolled in PACE. So she's done what she can.
Are there any other questions from any of the panel members for either counsel? All right, I see none, but the notice did offer you, Mr. Bosch, the opportunity to have a few more minutes of words. If you heard anything from Ms. Smith or anything else during this presentation that you'd like to address to the panel, please go ahead.
Thank you. I've heard a lot from Ms. Smith, frankly, and what's disturbing is that she's the one dictating, I guess, facts, misconduct and gross negligence and shortcomings and legal maneuvers which don't exist. What there is a court order that she be allowed to present to you, as she has done, her request for the same treatment this board gave Dr. Arthur Park. And yes, it wasn't the case that 2 deaths were immediately on the table, but 2 deaths were every bit part of the consideration in the same way that counsel for the Attorney General's office wants to declare her statements as fact when they're clearly not fact. This is a situation where we're looking for fairness for Dr. Chen's patients. We're not looking for any kind of legal maneuver. And she's not looking for some backdoor way to go delivering babies. She's done with delivering babies and obstetrics, and she understands that patient 1 and patient 2, even though healthy, happy babies, even though healthy, happy mommies, mothers, yes, one delivered cesarean instead of a natural birth and was disappointed. Neither one has ever filed a complaint or accused Dr. Chein of negligence or sleep apnea inability to perform. The sleep apnea issue is a red herring. I don't know how many people want to raise their hand as to having it. It hasn't prevented me from arguing here. It doesn't prevent Dr. Chein, who manages it completely in accordance with the way she's supposed to. And for counsel to argue that there's somehow gross negligence, dishonesty, that's dishonest. That's not a fair presentation of Dr. Chein before this committee, and it's not a fair representation of the people. And I'd say those 2,000 patients are people that deserve some consideration here, not counsel's statements of fact that are not fact. The idea that Dr. Chein wants to do anything at this point other than serve her patients is just wrong. It's just not true. There's no fact evidence for it. What there is the court telling on remand the Attorney General that there is case precedent by this board for separating gynecology from obstetrics. And this is exactly the kind of case where that should be honored as a precedent, primarily because this, notwithstanding counsel screaming gross negligence, misconduct, there's zero activity like a death of a patient or something that ought to concern this group. I mean, as far as what is happening to patients, what's happening to patients right now is they're being deprived of talking to the doctor they've relied on for years and years and years. And so we would request that the court's recognition of this as a, quote, good case for separating and with precedent before this board in a case where there's no basis for delivering to Dr. Arthur Park something different than is being visited upon Dr. Chein, separating it out makes a lot of sense. And why making sense, it doesn't work for the Attorney General is only a question for her. But for us, I think common sense and what the court has remanded this group to do is sensible. And we would like the opportunity to follow through on it, not for more legal maneuvering or administrative hearings. We've already indicated on a record here, she has no intention of doing any of that. So there's no ghost here or any type of, she's here before you because she wants to continue to serve her patients as she's done for many, many years. And that's selfless for her. She wants to help her patients and she's earned that respect. Doctor, do you want to say anything?
Yes.
You have
let
only a
me.
few more seconds.
Huh?
You only
There's
have a
only-
few seconds.
Okay.
Be a short
Please
time.
Please let me take care of my people. They've been with me for 10, 20, and 30 years. They learn to rely on me to take care of them for the gynecological needs. And then I have always been there for them, in any situation. And they're not ready for me to retire yet. You know what I'm saying? And I don't think those evidence presented to the board was a complete evidence because it was supplied by Providence St. John's. It's a partial record. And when I saw it before the hearing with the medical board, I supplied the hearing, the completed record, from the same computer epic system, but the hearing judge at that time thought that I just generated these phony records.
I'm going to ask you to. I'm going to ask you to wrap your remarks up, please. You've used your time.
Okay. All right.
Thank you.
I just want to take care of them. That's all.
Thank you. Ms. Smith, do you have anything else that you'd like to say? You also have 5 more minutes if you need them.
Your Honor, thank you.
I'm sorry.
It was Dr. Chen's choice to wait to enroll in PACE. She knew she needed to enroll in PACE as of the date the order was issued in March. She enrolled in October. The effective date of the decision was June of 2025. With respect to the Park case, it is not precedent. This case is not the same. The decision in this case followed a full evidentiary hearing where she was dishonest and lacked candor in her testimony. She admitted no wrongdoing. Dr. Chein is pulling at your heartstrings now while she's fighting your decision, and your priority is public protection. Dr. Chen's misconduct cannot simply be separated into one area of practice. And the Superior Court is not ordering you to allow her to practice gynecology. The decision is up to you. And the fact is that she had very serious deficiencies in failing to provide informed consent and her record keeping. And these issues are not exclusive to obstetrics. These findings at hearing relate to respondent Dr. Chen's unprofessional conduct as a physician and surgeon. Do not allow her to manipulate you into granting her an unrestricted gynecology practice while she waits for a ruling from the Superior Court on her challenge to your decision. To remove the necessary oversight of her practice will place patients at risk and be detrimental to public health, safety, and welfare. Dr. Chen's request to modify your well-reasoned decision that was issued in order to protect the public must be denied.
Thank you. All right. This board or this panel will take this matter under submission now. They will deliberate later on after hearing another argument as well, but that will conclude this argument. Thank you both, counsel, for your presentations. We'll go off the record.
Thank you.
Mr. Milano, is there anything before Mr. Bush and Dr. Chein go away and before Ms. Smith turns the table over to someone else, is there anything you need anyone to clarify or spell or repeat?
I don't believe so. I think there's a couple doctors, but I was on one of these hearings before, so I have all the spellings already.
Okay, great. Thank
I'm
you then.
present. Thank you.
All right. The next matter is the matter involving Chivano Chhieng. That matter is set for 2 o'clock, although if Dr. Chhieng is present on our video, perhaps we can go ahead a little early. Let's find out.
I've received an email just a few moments ago and asked them to join as soon as possible, but
Okay.
I don't see them yet.
Okay. All right. So we can certainly be adjourned for a few minutes until we find that person. Should we just take a break until 2 o'clock and people can stand up and walk around?
I can go ahead and put up a slide for that and
Why don't we do
check
that?
them in when they
That'll
come.
make it
Thank you.
easier. If anyone needs to have a conversation or walk around, you can do that, and we'll try to resume at 2 p.m. and hopefully Dr. Chhieng will be here then.
It looks like you've joined by phone. I've made you a panelist. You should be able to press *3 in order to unmute. Wanted to see if you're having trouble joining by the app. I'm sorry, not *3, *6. Try *6. Okay. Good afternoon. I can hear you now.
Yeah.
Were you going to
Can
be
you
able
hear
to
me?
join by video today as well?
Yes. How do I get on video?
I'm sorry?
Hello. How do I get on video?
You'd have to join through the WebEx application via that invitation I sent you.
Through my phone?
There's a WebEx app available for Android and iPhone.
Oh, you have to get the app for that?
Yes. If
Oh,
you
I didn't know
download
you
that
needed
from the App Store, you should be able to
Oh, I didn't know
click
you.
that
I didn't
link
know
in
you.
that invitation and it'll just open up, bring you in.
I didn't know you need an app. I need to download an app for this. Um, no one mentioned to get an app for the webinar.
I believe I mentioned it in that response I sent to you on the first, that as long as you join by video.
Let's see. It didn't mention any app to download. Can I
Yes, there's
download it
a small
now?
app. You could go ahead and download it right now. I
Okay,
can
one
help
second.
you out if you have any problems.
You want me to hang up?
No, don't hang up. Just go ahead and on your phone there, go to the App Store. I don't know if it's an Android or iPhone, but Google Play Store or Apple App Store and just search WebEx.
Okay, 1 second here.
No problem. Thank you.
Let's see. So it's WebEx. Okay. Here. Okay. So download. Is it the business one or the?
Emails.
It should just be titled WebEx.
Okay. Here. WebEx. Joining meeting. Okay.
Yes, if you already downloaded it and installed it, look for that invite that I emailed you and click on the join webinar link in there.
It says meeting number or link. Meeting number or link.
It'd be a lot easier if you went to that email I sent you and clicked on the link from there, but you can get all that information from that same email as well.
Let's see here. Okay. Join webinar. Join webinar, right?
Correct.
Join webinar. Okay. Name. Ask for name, right?
Yes, it'll join you with that name.
Email address.
Please put in the same email that we've been communicating with, and that way it'll recognize it.
Okay, here you go. I think I'm in. Join webinar.
Yeah, go ahead. Okay, now go ahead and hang up this phone call, and I will promote you for that. He was there for a quick second. Give him a minute to try again. Dr. Chhieng, if you're still hearing the phone version here, please go ahead and rejoin again from that link in your email. Okay, it looks like we got you now. You confirm you can hear us. You should be able to use the unmute button now.
Hello?
There we go. We can hear you. And you should see a button now to start video on the bottom. Could you mind turning that on?
I don't know what that is. There's,
Right down the bottom next to that mute button, it looks like a little camera. On the phone, it might not show the full thing, but right to the right of the unmute button. Dr. Chein, if you're still there down at the bottom, you should see a unmute button. Looks like a little microphone. Looks like you went back on mute. Dr. Chein, I'm also sending you some requests, so you should be getting a pop-up on your phone to mute there too, if you can unmute.
oh,
There we go. Okay, so
oh, here
now,
you go.
there we go. See your video there. Perfect.
All right.
Let me go ahead and get the camera back up here in the room, and I'll turn it back over to Judge Connie.
There we are. Okay, I think we're ready to resume. It's about 2 o'clock, and I
Ready.
see that we have our next petitioner, Dr. Chhieng, present. Good afternoon, sir. Can you say
Oh.
something to make sure that we're able to hear you?
Okay, can you guys hear me okay?
Yes, we can. Wonderful. All right. We also have, just for your benefit, since you're on the phone, you may not be able to see all the other little boxes. There are those of us here at the table. I'm Administrative Law Judge Juliet Cox from the Office of Administrative Hearings. We also have a few other audience members here in the meeting because we're in person in a hotel meeting room, and we have a court reporter present. So we're going to get started with your petition, or with the oral argument on your petition. So Mr. Milano, let's go back on the record. Good afternoon. We are now opening the oral argument in the matter of the petition for reinstatement to licensure filed by Dr. Chivano Chhieng. This matter is Medical Board case number 800-2024-105521. Today's December 3rd. It's about 2 p.m. and we have convened partly by video conference and partly in person for this oral argument. I'm Administrative Law Judge Juliet Cox from the California Office of Administrative Hearings, and the Medical Board has asked me to assist the board with hearing this argument. I'd like to start by having the participants introduce themselves, please, and I will ask Dr. Chhieng if you would introduce yourself formally for the record, please.
Good afternoon. I'm video conferencing from Guam, which is halfway around the world. So right now it's about 8 a.m. here in on a Thursday.
Okay, would you just state your name, please, so the court reporter can put it down?
Chivano, Chein.
Thank you. And for the complainant, please, or actually for the people, I guess, in this case.
For the people, good afternoon, Your Honor. Good afternoon, members of the board. Nilu Majd from the Attorney General's office.
Thank you. And can I have our court reporter also please introduce yourself for the record?
Yes, Your Honor. Your certified court reporter today is Nick Milana, and my CSR number is 13912.
Thank you. All right, it's my understanding that this matter comes to this panel for oral argument after a proposed decision on this petition that proposed reinstating Dr. Chhieng to licensure without any probationary conditions on that reinstatement. And the board has requested oral argument as to whether that's an appropriate disposition or perhaps there should be some other disposition of the petition. So what I believe is appropriate that we should do here, according to the instructions and the notices that you received, is we'll first hear from Dr. Chhieng. You'll have 15 minutes to explain to the board why you believe that essentially the outcome that was proposed is the best and most appropriate outcome here, based on the record that was developed at that hearing. Then we'll hear from Ms. Majd about whether the proposed decision's outcome is or is not appropriate. The panel members may have questions for you, and I'll invite questions both after Dr. Cheng's presentation and then also after Ms. Maj's presentation. And then at the end, each of you will have another approximately 5 minutes to address any other issues that you may have thought of because of what you heard the other participants say or what you heard the panel members ask. So, Dr. Cheng, are you ready to begin?
Okay. Yes. So I don't know what exactly oral argument is, but I basically my views. And,
Let me pause you just for a moment. We do have a court reporter who's going to take down everything that everyone says. So if you could be mindful to try to speak up and speak clearly into the microphone on your device, that will help our reporter take down what you say accurately. So please, the floor is yours for you to explain right now to the panel why you believe that the proposed decision that would reinstate you without any other conditions is the best outcome. But please, the floor is yours.
Okay, so my name is Chivano Chein, and a little bit about myself. I practiced medicine in the urgent care primarily for about 2 decades. I'm currently boarded with the ABFM. I was the chief resident of my family medicine training program in Riverside, California, and I'm a veteran of the United States Air Force, having served as a flight surgeon at March Air Base in Riverside, California. I currently work in the emergency department at Guam Memorial Hospital as a fast-track physician. And about the case was I voluntarily surrendered my California license A71847 July 2020 due to accusations from cases back in 2017 when I worked in the urgent care at Sharp Reese Dilley in San Diego. And I did so in order to continue practicing in Guam, which is an underserved community in need of physicians. Can you guys hear me okay? Because, okay.
We can, thank you.
Okay. So continuing on, so the accusations involve 3 cases. And I just want to clarify that in all 3 cases, there were no patient injury, harm, or death, no patient complaints or lawsuits. All the patients had good outcomes. In each of these cases, there is no relationship to each other. There were one-time incidences. They never having occurred before and never since. And, and so the question is, who brought up the accusations? I do not know why these incidents were brought up at the same time. I'm not sure why. I can put it into context. At the time this occurred in 2017, where I worked at Sharp Reese Dilley, there was a new chair of the department. He formed a peer review committee. And so the organization was used to press Gainey scores to evaluate physicians. And at that time when this happened, there were numerous providers that were quote unquote let go. So when they brought these cases up to me, I decided to resign. And when I did resign, what happened was they initiated they called 805 to the board. And so what happened then from then on was 2020, I received the accusations in the mail, which to me was a shock because I did not expect that. And so what happened? Normally, what happens is these incidents are handled by the chief doctor at each site, and there's 4 sites in the the Sharp system in San Diego. So he didn't go to protocol. Okay, so moving on. So about these cases. So what happened was, I'm going to discuss the first case, and these cases have learning points. So the first case involved a man with chest pain who had a STEMI. It was on a Monday, very busy. I glanced at the EKG and I saw ST changes, and I told the nurse to call for the ACLS transport. And I didn't realize there was STEMI until the transport came, at which point I told that there's a STEMI, and it's only 2 leads, what I didn't see initially. It was in the inferior leads, 2 leads. And I told the transport nurse to go 911 to the receiving emergency department. And again, it was a very busy Monday. So by the time I called the hospital, the patient had already arrived there. And so in any case, the patient did well. He had a stent placed. And so the learning point, what I took home was to always systematically and thoroughly review each document relating to a case and to take prompt action on any concerning findings, prioritizing what is important from what is not important. So what happened was I shouldn't have just glanced at the EKG. I should have looked through each leads like I normally do. But again, when you're rushed, you just kind of glanced and that's what happened. I shouldn't have done that. And so that's that case. The second case involved a man who had anaphylaxis. There was a verbal order given by me to the nurse to give epinephrine IM. Instead, IV was given. And concomitantly, orders for IV Benadryl and sodium Medrol was also given, and hence the confusion. So this case, what I've learned is to always maintain a closed loop communication, thereby preventing any adverse patient outcomes. And better yet, I've learned to minimize verbal communications and place orders myself in the system as possible. So minimize verbal and do more of my own ordering through the system. And third case was a man with a wrist injury from a motorcycle accident. He fell on his wrist from riding a motorcycle jump. X-rays showed a styloid fracture. It was a Saturday night. Normally, there's no X-ray readings available. I even asked a colleague to look at the X-ray with. He heard that he didn't see anything else. So neurovascularly, the wrist was intact, and so it was split. And we told the patient to follow up on a Monday.
I'm sorry to interrupt.
Thank
the
you.
connection's just breaking up a little bit. Maybe just pause for a second to let it catch up.
All right.
And if you
Thank
could
you. And
please, if you also, doctor, could please make sure to speak into the microphone of your device. It'll really make it easier for all of us to hear you. Thank you.
All right. Sorry about
If
that.
you could pick up from, it was a Saturday night. Normally there's no X reading. And then you asked a colleague to look at the X-ray. If you could pick up from there, that'd be great. Thank you.
Yeah. So it was Saturday night, and typically there's no X-ray reading Saturday night. I had a colleague look at the X-ray as well, and he concurred it was a styloid fracture. Again, the wrist had a neurovascular intact, so we splinted the wrist and told the patient to follow up on Monday in a fracture clinic. What happened with this patient the next day, I guess his symptoms were, he had more pain, numbness, tingling, and he went to the emergency department and they took him in for surgery. And so in retrospect, what I should have done was just call the radiologist on call and get a wet reading. Then I was a perilunate dislocation, in addition to the styloid fracture, which is not a common fracture. And if I would have spoken to the radiologist to get a wet read, I would have contacted the orthopedic doctor on call, and he might have been admitted for surgery the next morning. So the learning point from that is to, if I'm not certain, to take extra steps to confirm any studies and not to rely, because they may know just as much or less than you do. And doing so, having called the radiologist would have changed the outcome. And it would have been a better, I guess, more positive patient experience. And those are the three cases. Any questions so far? Or?
I think that I'll invite the panel to ask you questions when you finished your presentation, but if there's anything, you have about 5 more minutes, and if there's anything you'd like to say particularly about why you believe that reinstating you without any probation conditions, or if on probation, what conditions would be appropriate, if you'd like to address those questions now, you certainly should do so in your next 5 minutes or so.
Would that, in my conclusion, would that be the time to address that?
Why don't you go ahead and say anything you have to say about it now, and then there may be questions, or you may have something else you think of.
Let's see, where do I start? Okay, I'm sorry, it's trying to get a little theoretical here, but so since 2017, I practiced 2 years as a locums doctor at 2 urgent care groups in Orange County and Palm Springs. In 2019, I moved to Guam, and I practiced at the urgent care there for about a year, and then in the emergency department for about 3 years. And in all these places, I practiced as a solo independent practitioner, and I've had not one patient care issue, nor any patient complaints. I received a Guam Memorial Hospital Certificate of Recognition a year ago in October. And I just want to let the board know that, since those accusations, I've done well with no complaints. I've seen thousands of patients, and there were no adverse issues or concerns. And I just would like to request the board to consider, how my performance since then, and that I believe that it supports my request that I be reinstated in full without restrictions or conditions.
Thank you.
And
oh, did you have some? I'm sorry.
Oh, just one last thing. Yeah, my mom lives in California, and she's older and has health issues. So, I kind of want to plan to come back to practice there in the near future to be close to my mom. Thank you. That's it.
All right, let's find out if there are any questions from any of the board members. We'll start with the chair, Dr. Tsai. Any questions?
Yes. Thank you, Doctor. Thank you, Your Honor.
If you would identify yourself to
Yes.
the reporter too, that'll help.
Yes. Thank you, Your Honor. This is Viling Tsai. I have a question for Dr. Chein. I was going through your records, and during your petition for reinstatement, the ALJ in his documentation noted on page 8 that you indicated you had no intentions to practice in California. However, in your declaration that was submitted, you clearly stated that obviously you want to come back and hopefully practice in California because you have parents here. I just want to know, are you planning to come back, or are you not planning to come back? That will clarify.
Initially, I did not plan to, but because my mom's older and she's having some health issues now, which has gotten worse, I decided, that I would like to be closer to her. And that's the main reason, just so my mom, just to watch her and be closer.
Thank you.
Okay, thank you.
Vice Chair Chhieng, do you have any questions? Anyone else? Dr. Ayala.
Hi, this is Dr. Ayala Rodriguez. My question goes into physician performance. Like, was there a peer review process at one hospital, or how is physician performance reviewed?
usually if there's any issues, there's a doctor at each site. There's 4 sites. There's a chief doctor, and that incident will be discussed with the chief doctor, and usually that would be the end of it. And these things happen all the time. So this peer review committee that was started, I'm not sure why it was done and why we never had that before. And yeah, so this is all new to us.
And just for clarification, was this response that you provided about San Diego or about Guam? My question was specific to Guam Hospital. Like recent practice, have you been part of a peer review process?
No. This is all back in 2017 with the accusations. Is from Sharp, Reese Tilly in San Diego.
And just to clarify, because I work in medical administration too, a peer review process is not necessarily a disciplinary process. Sometimes it's a randomized process just to objectively look at the performance of physicians. So it doesn't necessarily means that there's a deviation of care. It's just the standard process that an institution might have to look at the performance of physicians objectively and randomized. Is there anything like that, do you know, in Guam?
In Guam here? There's no peer review committee, but if there's any issues, it would brought up with the chair of the department in the ER. Yeah.
Anyone else have any questions? Yes, Mr. Watkins.
Hi, Dr. Chein. My question, I've got 3 questions. My first question is, you were working as an independent from 2017 to 2019. What was your motivation for leaving to go to Guam?
I have a twin brother. He's also a doctor, and he works in Japan as in the Navy. He's the ER, and
Doctor, can you repeat? He's an ER. What? It broke up a little bit.
ER physician, ER doctor, and he worked in Guam before. And I've been to Guam in the past through the Air Force when I was a flight surgeon. And I wanted to be closer to my brother out in Japan, so that's part of the reason I went there to practice in Guam. So there's no state tax in Guam, which is nice. And we also like to travel Asia, so it's very close. It's 4 hours away to all the Asian countries like Korea and Japan, whereas from the States it's 15 hours. And they were looking for doctors as well where I practiced there.
So it had nothing to do with the accusation here in California or the pending investigation, is what you're saying?
No, because I was doing 2 years in California in locums, and I didn't hear from the board or anything. I thought everything was over, right? And so, and also there's California has very high taxes, so I was paying half my income to taxes. So and then that's part of the reason I moved. It was because of the accusations. I mentioned I was in the mail in Guam, 2020. I was like, what is this big packet, and yeah, that was a surprise.
So my next question, number 2, is when were you licensed in Guam? When did you apply to get licensed as a doctor in Guam?
2019, I believe. Yeah, 2018, 19. Because I started in Guam in 2019 of I believe it's April. Yeah.
Also, my final question, Dr. Tam was one of your colleagues.
Yes.
That wrote a letter of recommendation to you.
Mm-hmm.
And on page A105, page 234, there's a section in this that I just want to clarify.
Mm-hmm.
In the hearing transcripts, where it appears that Dr. Pham did not know about the details of the accusation in California.
Mm-hmm. I believe they contacted her and wanted to discuss that with her.
Yes,
So,
that's correct. They did
okay.
contact her and she didn't want to talk to the investigators at the time.
Mm-hmm. I think, I'm sorry.
No, you can speak.
No, I think I think it was a personal thing. She didn't want to get involved, you know, and she thinks it's not her role to get involved. And I spoke to her. I said, can you please talk to them, you know, and tell them about, you know, about me, my performance and everything. And she changed her mind and actually eventually spoke with the person.
Thank you. That's
Yes,
all.
thank
Thank you.
Anyone else have a question for Dr. Chein? All right, hearing none. Ms. Maj, you also have about 15 minutes to present the argument that you'd like to present regarding the propriety or lack thereof of the proposed decision. Please go ahead.
Thank you, Your Honor. Let me just make sure. This matter presents as a straightforward case. The petitioner previously surrendered his medical license effective July 2020 following the filing of the accusation. Since surrendering his California license, petitioner has maintained a medical practice in Guam since 2019, reportedly without any known complaints. The evidence, as the board had raised in their questioning, had raised some concerns about whether Dr. Chein wanted to practice in California. Based on the evidence on the record, it appears that petitioner intends to seek licensure in Hawaii and needs to have his disciplinary action in California cleared before he can practice in Hawaii. With that said, since petitioner has not practiced in California since 2019, it would be reasonable to, should the board reinstate Dr. Cheng's license, to have a probationary period of 3 years, a practice monitor, and for the clinical assessment portion, an enrollment in the PACE program to ensure public safety, given the lapse of time that Dr. Chein has been practicing in the state of California. And that's all I will say.
I'll find out if there are any questions from any of the panel members to Ms. Maj. I see some shaking heads. Is there anything else you'd like to say? Presumably the proposed decision addressed, you must have made similar arguments. Is there anything in particular you'd like to say about the proposed decision's recommendation against probation conditions?
No, Your Honor.
Okay.
And I just want to make sure that I added this, that in addition to the clinical assessment via PACE and probation, it would also be reasonable to have a practice monitor. I just want to make sure that's on the record if I didn't mention that.
I think you did mention practice monitor, but thank you for making it clear.
Thank you.
I see no questions from the panel. So I'll turn it back over. I'll turn the floor back over to Dr. Chein. Is there anything else then that you'd like to say to support your position based on the questions that were asked to you, or based on what you've heard counsel say here in argument against the proposed decision?
I just want to say that I don't know what the PACE program is and what a practice monitor is. I just want to emphasize that, you know, like I was saying, I've been independent, practicing, you know, without a monitor for the ever since accusations, and not one patient complaint, not one patient care issue, and I think I'm pretty proud of that. So I don't see the rationale for having someone to monitor me or some kind of program. I am board certified, and I'm fully licensed in Guam. So it just doesn't make sense to me. That's all I have to say. Thank you.
Ms. Maj, is there anything else that you'd like to say then as a last word?
Nothing further. Thank you.
Okay. Any other questions that have occurred to anyone? All right, with that then, the panel will take this matter under submission as well. And they will retire to closed session soon to deliberate, and they'll render a decision in writing. So thank you all very much for your presentations. We'll go off the record. But Dr. Chein, don't go away, because Mr. Milano may need for you to repeat or clarify something. Mr. Milano?
Okay.
Thank you for asking. Was the doctor that was mentioned Dr. Payne? Would you be able to spell that for me? I think Dr. Watkins was asking about.
Dr.
It was someone who had provided a reference for you, Dr. Chhieng. Was it FAM?
That's THAM, Moping, MOPING, last name Tam.
Oh, Tam. Okay.
Thank you. And 1 second, let me quickly look at my notes. You were talking about an organization at Sharpry Steely. Did you say press gain scores to evaluate physicians?
Right. Press
Can you
Ganey.
Okay. I can
I
look
think
that up.
PRESS GANEY.
G-A-N-E. Thank you.
Press.
Yeah, and one more. That was the last one. I appreciate
All
that.
right. Thank you very much for your help today, Mr. Milano. Thank you, Dr. Chhieng. Thank you, Ms. Majd. I think that will conclude this particular argument. So.
Thank you. Do I hang up?
Yes, you may, sir. Thank you very much for being here today.
Okay, thank you. Thank you. Thanks to the board.
Okay, we'll go back to the agenda item on panel A of the medical board meeting. Currently, we have concluded with our hearing, and so we will move to closed session. We'll have to.
Thank you, Dr. Sai, we'll go ahead and leave this session open for anyone who would like to remain here, but we'll just have a slide up that we're in closed session. We'll return for adjournment a little bit later.
Thank you.
Cassandra, give me just a few minutes to open up the next session and we'll clear the room out for deliberations.
Judge Cox, did you need anything else from the court reporter?
I don't believe so. It's my understanding that the medical board retained the reporting services today, so they will arrange whatever they need to arrange with you to make sure that you're paid for being present and for reporting for us. So I don't have to fill out one of those forms, I don't think. So if you have all the information you need to make a clear record, then I think we're done.
I do, and thank you. I appreciate
All right.
it.
Thank you very much for your help today.
My pleasure.